clearly apparent that the Rigathi Gachagua was unable to attend to the Senate sessions to defend himself. Well, it was decided, and procedurally and unconstitutionally so, that the proceedings of the Senate will proceed, and regardless of the timelines that have been set in the Constitution, which, for the avoidance of doubt, required the senators to sit up to the 19th day of October to adjudicate on this issue and to decide whether there has been sufficient grounds, at least from the evidence that has been presented and the defense that would have been presented by Rigathi Gachagua, whether it is sufficient to remove him from office. We saw that the senators, the honorable senators, presided over or under the authority of the Speaker, Amason Kingi, decided in one accord that they will proceed with the proceedings. Consequently, declining to entertain an adjournment of the proceedings to a later date to allow Rigathi Gachagua, Honorable Rigathi Gachagua, to have his day at the Senate to defend himself. Now, the question that we ask, in view of Article 145(6) of the Constitution, it requires, or it gives Rigathi Gachagua, or it gave Rigathi Gachagua the unfettered right to be present during his hearing and to defend himself of all the accusations, the 11 accusations that were made against him. So to that extent, we are inviting the court to look and to review that process and to make a finding that indeed the ostracizing, or rather the decision that was made by the Honorable Speaker declining an application for an adjournment of the proceedings to a later date was unconstitutional, and to that extent it has affected or tainted the whole impeachment process. Secondly, today we have witnessed, through a communication from the President of the Republic of Kenya to the Speaker of the National Assembly, we have seen there has been a communication communicating a name, a proposed name of the Honorable Professor Kithure Kindiki as the nominee by the President to replace the Deputy President, then Rigathi Gachagua, in the office of the Deputy President of the Republic of Kenya. So there are a number of constitutional concerns that arise or follow from that. The Constitution requires that a person nominated for the position of the Deputy President or the President under Article 137 of the Constitution must meet certain requirements, and at the very least, he must not be a state officer. Professor Kithure Kindiki, as we know as at now, is still serving the Republic of Kenya as the Minister or the Cabinet Secretary in charge of Interior Security. So we are calling the court to quash, or rather to declare as unconstitutional, the appointment of Professor Kithure Kindiki as a replacement of His Excellency Rigathi Gachagua in the office of the Deputy President, as he is unfit, he is unqualified, and he does not meet the threshold that has been set under the Constitution of the Republic of Kenya. Secondly, there are other concerns that beg the attention of the court, and we are inviting the court to make some of these decisions. We know as of now we do not even have the IEBC. The IEBC is the custodian of the names of individuals who are, number one, registered voters in the Republic of Kenya. Number two, it is the IEBC that knows too well whether you belong or you hail from a certain political outfit. And for that reason, knowing too well that you cannot fit to be a nominee of the position of the Deputy President if you are not, number one, a registered voter, it then behooves the IEBC to work in tandem with the President and the National Assembly for the vetting process to be ultimately approved by the National Assembly of the Republic of Kenya. As it is right now, we do not have the IEBC. The IEBC is not properly constituted. To that extent, then you want to ask yourself, how is it that the President has nominated the person of Professor Kithure Kindiki to to fill that vacancy that has been left following the impeachment or the decision to impeach the Deputy President Rigathi Gachagua from office, yet there has not been any vetting or rather there has not been any input by the IEBC, which is not currently constituted. So we have invited the court, and this is what we shall be doing in the fullness of time when the court allows us to have an expanded bench to hear and decide on these questions. We are ultimately going to invite the court to declare the appointment or rather the subsequent nomination of Professor Kindiki to be unconstitutional, and for that reason we will want that we return to the status quo ante until we have a respect of the current constitution of the Republic of Kenya. We shall not relent. We shall continue pressing on to ensure that the government of the day is called to question, is called to account so that it can respect its current constitutional dispensation. At the very least, we have seen a regime that is subjecting us to what we call the microwave experience. Things are being done in a very fast and speed manner. We had hoped that this would be the fashion in all its doings, but we have seen a selective way in which this process is being done, in a manner to suggest that there was a predetermined outcome in the process that has now ultimately led to the removal of office of Rigathi Gachagua from office as the Deputy President of the Republic of Kenya. So I thank you. We are expecting we get the results from, we get directions from the Honorable Court as and soon as and when we shall get the directions from the court, we shall make these directions available to you. Thank you.
The Speaker had said that he's working against the timeline.
Yes.
Which will be ending tomorrow.
Yes.
Did the Senate have the judicial or constitutional mandate to extend that time outside the prescribed time by the Constitution?
Well, it is well known to all of us that the Deputy President Rigathi Gachagua fell ill yesterday when he was expected to make his defense. We also know too well that the constitutional timelines, the Constitution grants us 10 days within which to investigate and ultimately arrive at a conclusion whether the allegations made against a sitting Deputy President or a President has been, substantiated. So we expected, now that the Senate decided that this matter should be heard in the plenary on the 9th day of October 2024, then the 10 days will have ordinarily ended on the 19th day of October 2024. So to that extent, there was no emergency. There was no any sense of urgency that would have pushed the Senate to make the decision that it made yesterday. What then were we to do today? What then were we supposed to be doing tomorrow? It was well within the powers of the Honorable Amason Kingi to adjourn those proceedings to today, which is still a working day, and to have given the Deputy President at least a benefit of doubt so that he can recover from what he is said to be suffering from.
Just like civil proceedings.
Yes.
Mr. Gachagua had been given time to file.
Yes.
All the evidence answering the 11 accusations.
Yes.
He did so in 3 pickups.
Yes.
He presented it before the Senate.
Yes.
How can you fault the Senate for its decision, yet he had put his defense?
Well, the Constitution demands, or rather the Constitution grants a right to the Deputy President Rigathi Gachagua to appear in the Senate to defend himself in the presence of his lawyers. So the only person who has that opportunity or privilege of waiving that right was Rigathi Gachagua Geoffrey, the then Deputy President. So to the extent that the senators decided that the proceedings will continue in his absence was in violation of the Constitution.
We thank everyone who has made time today to come and hear us. We thank you for giving your support towards us as we file this petition. We understand that this is a matter of national interest. My name is Hemon Odhiambo. I'm an advocate of the High Court of Kenya, and I am here with my fellow counsels, my senior counsel Shadrach Wambui, and we are very glad and blessed to have all of you here to lend your support, to come and view, to come and support our petition, and to help us as we fight for justice and for the rule of law and constitutionalism. Thank you so much.
afternoon, members of the press. My name is Magdalene Wanjiko. I'm an advocate of the High Court of Kenya. Today we have filed a petition before the High Court at Nairobi, in which we are seeking, we are challenging the process under which the impeachment of the Deputy President, Honorable Rigathi Gachagua, was conducted by the Senate yesterday. And part of what we are challenging is the manner in which the process of impeachment was done. And we are saying that the Constitution is the grundnorm and it has to be respected. Anything that is done under the Constitution has to be done within the processes that have been prescribed by the Constitution. Any political interferences, political play must not be evident, because it then befits what the Constitution intended for it to happen. And we are looking forward to seeing the decision of the High Court and the orders that will be granted later today. Thank you.
The Deputy President.